But if we can return, and that means if the people themselves can start to understand what it is to be an individualist, that's respecting each other's individual rights. It's, for example, it's free speech has come up for you in Scotland at the moment in quite a big way. It's an individualist would understand that and fight for the right of the person that I disagree with fundamentally also to be able to express what they think and believe. Yeah. And that's an example of an individualist in how they think. Yeah. And so that's absolutely key and at the heart of the English Constitution. It's the people in an equitable society that take part in the formation of the moral character and the laws of their community.
In what way was that high ideal, were those high ideals enshrined in, for example, the Great Charter, Magna Carta?
So yeah, there are a number of...
What's there in Magna Carta that we've lost? Because people always say to me, yeah, Magna Carta's been superseded by and it's out of date and it's all been blah, 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 blah. What was there in Magna Carta that's so important that we've lost now?
So Magna Carta 1215, the original Great Charter, which, by the way, is not legislation. They can't repeal it. They might claim they can, but they can't. It's not legislation. It's customary law.
What is it then?
Customary law. So it's known as legem terrae or lex terrae, which is the law of the land. The original definition of the law of the land, which came from the English strain of law that comes from the late Saxon kings, and earlier, and much earlier too. But not only, actually. In fact, most of Europe was functioning under common law as well. So common law principles were extant all over Europe, generally, actually. But just to answer your question specifically, there are a number of chapters of the 1215 Magna Carta, a subset, that are regarded, they're known as the Articles of Common Law. That's where your common law is. So when people talk about common law, an awful lot of rubbish is being talked about common law, actually. But what you should be doing if you're talking about common law is calling it constitutional law. Okay, so, because that's what it is, really. Constitutional law is common law. And the Articles of Common Law that exist within Magna Carta is a subset, but the most important being Article 39 and Article 40. There are others too. Let's focus on those during this. And Article 39 in particular is really important because that's what's giving us the right to a jury of our social equals, so that when we are judged, we can't receive punishment without the judgment of a court of conscience. That's what it's basically saying. But interestingly, about 200 years before 1215 Magna Carta, that same principle was expressed in other places at other times, but in particular by Emperor Conrad himself, a Roman Catholic as well, interestingly, where he said, no one shall lose his estate unless according to the custom of our ancestors and the judgment of his peers, Same principle, 200 years earlier than Magna Carta. So this was going on way before. And you've also got, the history of Alfred the Great in the late 1800s, hanging judges for going against the jury, the decision of the jury. So this idea, so not only have we got trial by jury established as a principle, but the most important principle, which is that the jury must have the power and the right to disagree with any legislation from government, if you do have a government at all, right? So any legislation that might be in place can be disagreed with.